Hello students and welcome to the lecture. So students, as you could see that basically in this lecture we are going to talk about the emergency provisions. All right. And basically these are the topics we have scheduled for the discussion under this particular series of the emergency provisions. All right. Like starting with the introduction part, thereafter the national emergency, thereafter the parliamentary approval and the durations, thereafter the president's rule, thereafter the financial emergency, then the criticism of the emergency provision. All right. So let's start with the introduction part first. So if we look at the introduction, so what we will see that the emergency provisions are basically contained in the part of this of the constitution, and the articles are ranging from this one 352 to 360 articles. All right. In the part 18. All right. So these provisions enable the central government to meet any abnormal situations effectively. So what we have seen that whenever there is an abnormal situations in the nation or any part of the nations, then the government could use these provisions which were enumerated between the Article 52 to Article 360 in the part 18th of the Constitution. All right. The rationality behind the incorporation of these provisions in the Constitution is to safeguard the sovereignty, unity, integrity, and security of the country. Okay, for these three areas. And in the, you can say, addition to it, basically the democratic political system and the constitution. So whenever the danger is on these areas, the government could impose the emergency provisions in the country. All right. During an emergency, the central governments become all powerful and states go into the total control of the center. It means it converts the federal structure into the unitary one without a formal amendment of the constitution. Okay, like we had seen that the federal structure is the part of the basic structure of the constitution, and this could not be changed and affected without making the formal amendment of the constitution. But whenever it's a matter of emergency provision, then the federal structure could be converted into the unitary one without having any formal amendment. This kind of transformation of the political system from federal during the normal times to the unitary during emergency is a unique feature of the Indian Constitution. All right, now let's move ahead. In this context, Dr. B.R. Ambedkar, who was the drafter of the Constitution of India, observed in the Constituent Assembly that all federal systems, including the American system, are placed in the tight mold of feudalism. It means that they could not be converted that easily. No matter what the circumstances, it cannot change its form and shape, can never be unitary. On the other hand, the institution of India can be both unitary as well as the federal according to the requirements of the time and the circumstances. All right. In normal times, it is framed to work as a federal system, but in times of emergency, it is so designed as to make it work as a though it was a unitary system. Okay, so that was the statement made by the Dr. B.R. Ambedkar. Thereafter, the Constitution stipulates three types of emergency. First kind is an emergency due to war, external aggression, or the armed rebellion under Article 352 of the Constitution, properly known as the national emergency. However, the Constitution employs the expression proclamation of emergency to denote an emergency of this type. Okay. Thereafter, an emergency due to the failure of the constitutional machinery in the states under Article 356. This is popularly known as the President's Rule, known by the two other names, state emergency or the constitutional emergency. However, the Constitution does not use the word emergency for this situation. Basically, we use the term President's Rule in such kind of situations. All right. The last one is the financial emergency. The financial emergency is enumerated under Article 360 and could only be, you can say, implemented when there is a threat to the financial stability. So, basically, Article 352, 356, and 360 having the provisions of the emergency. Thereafter, what are the grounds of the declaration? Under Article 352 of the Constitution, the President can declare the national emergency when the security of India or part of it is threatened by war or external aggression or the armed rebellion. Thereafter, it may be noted that the President can declare a national emergency even before the actual occurrence of war or external aggression or the armed rebellion, if he is satisfied that there is an immediate danger. It means that only the President can declare the emergency after the proclamation of the Parliament when he sees the occurrence of war or external aggression or the armed rebellion, and it's satisfied that it is an imminent danger in front of the nation. Thereafter, the President can also issue different proclamations on ground of war, external aggression, armed rebellion, or imminent danger thereof, whether or not there is a proclamation already issued by him and such proclamation in operation. This provision was added later by the 38th Amendment Act of 1975. It means not only the national emergency proclamations could be added on these matters, but other could be added also by the President of India. Thereafter, when a national emergency is declared on the ground of war or the external aggression, it is known as the external emergency. So there are two names for the national emergency: external emergency when there is a war or the external aggression. On the other hand, when it is declared on the ground of armed rebellion, then it is known as the internal emergency. All right. Thereafter, a proclamation of national emergency may be applicable to the entire country or only part of it. Okay. The 42nd Amendment Act of 1976 enabled the President to limit the operation of national emergency to a specified part of India. It means that doesn't matter whether its name is national emergency, it does not mean that it will be applied all over of India. Or you could say all over India. Basically, it could be restricted to a specified part of India. All right. Originally, the Constitution mentioned the internal disturbance as the third ground for the proclamation of the national emergency, but the expression was too vague and had a wider connotation. It means that external emergency is well defined when the war is there or the external aggression is there, but when it's come to the internal disturbances, then the things are not so clearly defined. Hence, the 44th Amendment Act of 1978 substitutes the word armed rebellion for the internal disturbance. It means that whenever there is a condition of Mayavad and whatsoever, so the national emergency could be declared on the grounds of internal disturbance. Thus, it is no longer possible to declare national emergency on the ground of internal disturbance, as was done in 1975 by the Congress government headed by Indira Gandhi. It means that until or unless there is a situation of armed rebellion, no government could declare the internal disturbances national emergency because internal definition is with the armed rebellion. All right. The President, however, can proclaim a national emergency only after receiving a written recommendation from the cabinet. This means that the emergency can be declared only on the concurrence of the cabinet and not merely on the advice of the Prime Minister. In 1975, then Prime Minister Indira Gandhi advised the President to proclaim emergency without consulting her cabinet. All right. The cabinet was informed of the proclamation of emergency after it was made and as a fait accompli. All right. Thereafter, the 44th Amendment Act of 1978 introduced this safeguard to eliminate any possibility of the Prime Minister alone taking a decision in this regard. It means that basically the cabinet approval is necessary while making the proclamation of emergency and while suggesting the emergency to the President of India. 38th Amendment Act of 1975 made the declaration of national emergency immune from the judicial review. It means that national emergency proclamation could not be challenged in any court. Okay, but later this provision was subsequently deleted by the 44th Amendment Act of 1978. All right. Further, in the Minerva Mill case 1980, the Supreme Court held that the proclamation of a national emergency can be challenged in a court on the ground of malefied or that the declaration was based on wholly extraneous and irrelevant facts or observed observers. It means that Supreme Court said that the proclamation of the national emergency could be challenged in the court if the things were not well defined, if that was a malefied, and if the reasons were irrelevant and absurd or perverse. Okay. Thereafter, the proclamation of emergency must be approved by both houses of parliament within 1 month from the date of its issue. It means that suppose if the proclamation was issued on 1st January, it should be passed by both the houses within the first month. It means till 31st January. All right. Originally, the period allowed for approval by the parliament was 2 months, but was reduced by the 44th Amendment Act of 1978. Okay. It means that if the proclamation is not passed by both the houses within the 1 month, the proclamation will be revoked automatically. However, if the proclamation of emergency is issued at the time when the Lok Sabha has been dissolved or dissolution of the Lok Sabha takes place during the period of 1 month without approving the proclamation, it means that when the proclamation was presented in the month of January, the Lok Sabha was not in the session because it was dissolved. Then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Raj Sabha in the meantime approved it. So if the Raj Sabha approved the proclamation from the 1st January, 31st January within it, so suppose the Raj Sabha the Lok Sabha again was appointed in the 1st March. So till this time period, the proclamation will be survive and must be passed. All right. If approved by both the houses of the parliament, the emergency continues for the 6 months, can be extended to an indefinite period with an approval of the parliament for every 6 months. It means that suppose if the proclamation was passed in the month of January, so it will be in the force only up to June or July basically for the time period of 6 months. If the proclamation must be, or you can say is to be extended, then basically the parliament will again give the approval for it. All right. Thereafter, this provision was periodically parliamentary approval was also added by the 44th Amendment Act of 1978. All right. Before that, the emergency, once approved by the parliament, could remain in operation as long as the executive desired. It means that the approval provision within 6 months was added by the 44th Amendment Act of 1970. Prior to this, basically, the parliament, if once approved the provision, then it was totally depend upon the executives or the cabinet till when they want to continue it. Okay. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuation of emergency, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Raj Sabha in the meantime approved its continuation. So basically, we could say, suppose if the proclamation was passed in the month of January, as I have told you that will be survive only for the 6 months as per the provision added by the 44th Amendment Act of 1978. All right. Now, what's the situation here? Suppose within this 6 months, the Lok Sabha dissolved. All right. So basically, if the Lok Sabha was reconstituted in the month of July, so till 1st July to 31st July, the proclamation will be survived. It means within 1 month of the reconstitution of the Lok Sabha, the provision will survive. After this, the provision will be expired automatically. But there is a condition that meanwhile, the Rajya Sabha must pass the continuation. Okay, it means that only the Lok Sabha is dissolved in this 6 months and the Rajya Sabha pass the provision for the continuation after the July. So from 1st July to 31st July, the proclamation will be valid if within this month the new Lok Sabha was sitting. Okay. Thereafter, every resolution approving the proclamation of emergency on its continuance must be passed by either House of Parliament by a special majority. Okay, which means that a majority of the total membership of that house, a majority of not less than third 2/3 of the members of that house present and voting. For example, suppose like if we talk about it, so suppose this is a Lok Sabha, for example. Okay, in Lok Sabha there are 150 members, for example, sitting in it. So basically, if we talk about the case of simple majority, so what the simple majority says that more than 50% of the members must be in favor of the passage, then thing will be passed on. It means that suppose if the 78 members in the favor of the continuation, okay, so it means that it is more than 50%, right? More than 50%. So that is a case of simple majority. But when it's come to the special majority, then it demands two things. First, majority of members sitting and voting. Second, 2 by third majority of members sitting and voting. All right, which means that not only the 78 members must be in the favor, but 2 by third. It means that suppose if the 100 members are in favor of the continuation of the emergency, then the resolution will be approved or passed. Okay, like if we look at here, 78 members were in favor. Okay, but is 78 members is only the more than 50%, but it's not the 2 by third majority. It means that if that will be the case, in the case of special majority, the resolution will be failed. But if that is the case, so 100 members is not only more than 50% of the members sitting and voting, but also 2 by third. And here is a one thing which we could see here is the sitting and voting. Okay, sitting and voting. What does it mean? It means the members must having the voting rights. For example, let's take example. Like suppose if there are total 150 members sitting, but out of these only 125 members, for example, having the voting rights. All right. So whatsoever the majority of members will be counted, whether it's a simple majority or special majority, that will not be counted on the 150 members. That will be counted on 125 members. Why? Because the condition is not only for sitting, the condition is for sitting and voting. It means that the members must having the sitting and voting rights both, not only one. Okay. This special majority provision This special majority provision was introduced by the 44th Amendment Act of 1978. All right. Previously, such resolution could be passed by the simple majority of the parliament. It means that prior to the 1978, or you can say the 44th Amendment Act of 1978, only the simple majority was required. It means the passing of the resolution was much easier in comparison with today, because today we require the special majority. Okay, it means majority of members sitting and voting, 2/3 majority of members sitting and voting. But priorly that was easy. Why? Because only the 50% requirement was there. Thereafter, so far we had just discussed the implementation, or what? Implementation or continuation of the emergency. Now, basically, we are going to talk about the revocation of the proclamation, or you can say seizing the national emergency provision. So, how this could be done? First, a proclamation of emergency may be revoked by the president at any time by a subsequent proclamation. Okay, it means that the president having the power that he could revoke the proclamation of emergency, okay, by passing a proclamation for it. Thereafter, such proclamation does not require the parliamentary approval. It means that to implement the, you can say, the emergency, the president requires the approval of the parliament. But for seizing it or for revoking it, there is no requirement to obtain the parliamentary approval for it. All right. Further, the president must revoke a proclamation if the Lok Sabha passes a resolution disapproving its continuation. It means that suppose for the initial months, or you can say initial 6 months, the continuation of national emergency was done. But after it, what happened? That basically the parliament was not in the favor to continue the national emergency. So what happened? The parliament will disapprove the continuation. Sorry, Lok Sabha will disapprove the continuation, and then the president will revoke the national emergency by passing the proclamation. Again, this safeguard was introduced by the 44th Amendment Act of 1978. All right. 44th Amendment Act of 1978. Before the amendment, a proclamation could be revoked by the president on his own, and the Lok Sabha had no control in this regard. Okay, it means that prior to the 1978, only the president having the right to revoke the emergency. It means Lok Sabha was not allowed to take participation in the revocation of the national emergency. But when the 44th Amendment Act of 1978 was introduced, then basically that comes over the Lok Sabha, or you can say Lok Sabha get the power so that they could pass a resolution for the discontinuation or disapproving the continuation of the national emergency, and then the president will revoke the national emergency. All right. Thereafter, a 44th Amendment Act of 1978 also provided that where 1/10 of the total members of the Lok Sabha gave a written notice to the speaker or to the president if the house is not in the session, a special sitting of the house should be held within 14 days for the purpose of considering a resolution disapproving the continuation of the proclamation. So what we have seen here, that suppose 1/10 members of the Lok Sabha, okay, they want that the discussion must be held on the resolution to be passed disapproving the continuation of the proclamation. All right. So basically for this, they having two chances, and two chances, you can say two ways. First, when the house, or you can say Lok Sabha is in session when the House or Lok Sabha is not in session. There are two chances. So, at the first chance, they will talk with the speaker. In the next chance, they will give the written notice to the president. All right. So remember this thing. When the House or the Lok Sabha will be in the session, the speaker will receive the notice. When the House or Lok Sabha is not in the session, the president will receive the notice. All right. And basically, after receiving the notice, the special sitting. Why? Because this is only for the resolution, or you can say considering a solution, disapproving the continuation of the proclamation. Okay. So within the 14 days after receiving the notice, the special sitting must be appointed of the House. Okay. A resolution of disapproval is different from a resolution approving the continuation of a proclamation. All right. It means that there is a difference between these two provisions, like proclamation of continuation. Second one is proclamation of discontinuation. Okay. So what's the difference between them? Basically, these are the two difference in them. First, the first one is required to be passed by the Lok Sabha only, while the second one needs to be passed by the both houses of the parliament. Okay. Thereafter, second difference is the first one is to be adopted by the simple majority only, while the second one needs to be adopted by the special majority. It means that when that is the proclamation of the continuation, then both houses and special majority is required. All right, both houses and the special majority is required. But when it is for the discontinuation, then Lok Sabha only and simple majority is required. Okay. So that's a difference between the two. What are the effects of the national emergency? A proclamation of national emergency has drastic and the wide-ranging effects on the political system. These consequences can be grouped into the three categories, named as first, the effect on the center-state relations. Thereafter, the effect on the life of the Lok Sabha and the State Assembly. Then the effect on the fundamental rights. Okay. So whatsoever effect and the consequences will be held on the center-state relations. All right. And the political system and the structure of this country as per the Constitution of the India, the rule book of India, that effect could be divided into the three categories: effect on the center state relations, effect on the life of the Lok Sabha and the State Assembly, and effect on the fundamental rights. All right. But I don't think that we have a sufficient time to discuss these things in this lecture for the proper and the comprehensive way. So basically, what we will do that we will discuss these things in the next lecture in the proper manner. Okay. We will discuss them. We will try to draw some conclusion. We will try to understand them comprehensively. Okay. So that if any questions come in the examination, tricky or non-tricky, that we should be able to answer the thing correctly and confidently. All right. So with this note, let's end this lecture and thank you.